judicial.
My Lord, I will conclude my opening submissions in the allotted time. If I am going over, I've discussed it with my learned friends, I will borrow from my reply, so they won't be disadvantaged in any way.
Very well.
My Lords, in summary, my submissions yesterday were that there was an error of law by the learned judge in his approach to the principles of fairness, in that he followed the guidance of the Vice President in Balajigari, whereas the proper approach should have been to follow Lord Sumption's approach in Bank Mellat, which is essentially an open-textured approach to the question of fairness, depending on the particular circumstances. If you are with me on that submission, and that there was an error of law, then of course it would be open to this court to make its own findings on fairness, and I'll come to that later on as to how I submit you should reach that conclusion. Of course, my submission will be that you should find that the current system, or the system that applied at the time of the claim, was fair. A further challenge to the judge's decision relates to a couple of factual errors, which we say also infected his decision, although if you're with me on the general principle that I've already articulated, one doesn't need that, but they are, we say, additional errors. And they're referred to in paragraph 24 of our skeleton argument, and that's ground 4 of the appeal. I think in the electronic bundle, that's page 28 of the core bundle.
Do you want us to look at that now?
Well, I'm just going to... That's just where it is, my Lord.
Thank you.
And yes, if you have that available, that would be helpful. But essentially, in the judgment, at paragraph 213, so it's core bundle 141, the judge states that although this is the issue in this case, and that's, my Lord, that's 141 in the core bundle, the matter at issue may not be as significant for the claimants as the issue for those who've been sentenced to life imprisonment in duty. It is nonetheless of real and significant importance for the claimants. A TPD may result in a reduction of up to 25% of their benefits, a very significant sum, especially as the claimants will be on low incomes. And this is material to the judge's decision, because we can see that at the beginning of the next paragraph, 214, where he says, given the impact of a TPD upon a claimant, and bearing in mind the guidance in duty and the other authorities referred to above. So this does lead directly to his conclusion. But my Lord, the finding, or the statement that the TPD would be of 25% of the claimant's benefits is itself an error, because it's not 25% of all the benefits that a claimant may have, and it may not even be 25% of the particular benefit from which a deduction is made. So in this example, employment and support allowance, as I showed you yesterday, part of that benefit, the support group payment, does not get included in the 25% applicable amount. So the judge erred in thinking that there is a greater amount of benefit that is actually used for the TPD, so therefore less money available to the benefit claimant for them to make their other spending
I need some help with this. What the judge says is that it may result in a reduction of 25%, not that it inevitably will. So if a benefit claimant only has benefits which are subject to deduction, it could be 25%.
It could be in those circumstances, yeah. but
So why is the judge wrong?
But he's making a general proposition and the reference to benefits, I submit, assumes that it's not just the applicable amount of a benefit.
Forgive me, you're
it's the
saying
entire
here that
benefit.
the judge's decision is perverse. And as I understand it, he says that a TPD may result in a reduction of 25%, and he later says up to 25%. So are you saying that that is a perverse statement?
Well, up to 25% is because the TPD can only reach a cap, but it's the reference to total benefits that I'm referring to as being the perverse finding, because he should have made it clear that he's only referring to the specified benefit and the applicable amount of the specified benefit. The assumption that I am putting to you is that he thought there was a greater intrusion than in fact there is.
Right, that's it, is it? That's his error.
That's that error.
Right.
And, my Lord, then there's another error which we identify at paragraph 110, which is in the core bundle 117, which is a finding that, in light of the evidence before me, it is clear that the decision maker, so this is 117 of the core bundle, it is clear that the decision maker would simply have before them the details from the spreadsheet. Whereas in fact, the evidence before him was that decision makers would also have available to them the various matters that were referred to in Claire Waterman's statement, which are the various other databases which would give the decision maker more information about the claimant.
Was there evidence that the decision makers did actually look at that material?
The evidence was that they have access to that. That's as far as the evidence went.
And they weren't encouraged in the guidance to avail themselves of that opportunity, or required to.
They certainly weren't required to. I accept that. The guidance doesn't say you must look at that, but it is available to them. So insofar as the judge didn't include that in his finding, we say that's a perverse finding.
What happens presumably is that the schedule arrives on somebody's desk and it is populated with up to 50 names. Yes. And there is then some process by which somebody does something, but we don't know what.
Well, I can't assist you any further with that, my lord, but you're right. They will receive a spreadsheet, but then they'll have to take the information from that spreadsheet to then
make
a decision.
As far as we know, somebody might just put a stamp on and say all of those 50 are approved.
Well, my lord, there is no evidence in front of you as to how they precisely make that decision.
There's no explanation of why there is no evidence, because the witness is in charge of this area. She's in a position to know.
Well, what she has said, what she says is this is what they have available to them.
Yeah.
Now, those are our specific points on perversity. My lord, I also want to refer you to the examples that the judge gives in his judgment as to when he says, well, these are circumstances which might make a difference, and those are his hypotheticals. He gives those examples at paragraphs 188 to 192. My learned friend, Mr. Cockle, on behalf of the interested party, will make submissions in detail on those matters, and I endorse those submissions. All I wish to say at this stage is that those hypotheticals do not support a conclusion that representations must be sought in advance by the Secretary of State. The examples given consider the guidance to decision makers in isolation from the scheme as a whole. There are, as I've sought to submit yesterday, considerable administrative processes which take place in advance. These are not examples that were suggested at all by the claimant or any way related to the way in which she would have wished to raise matters. And also, they are examples where a representation would be unlikely to make any difference to the outcome other than in a very rare case. Those are my submissions on that. My learned friend will go into them in more detail.
Well, this is a case, it's a situation where we have, you might call, a known unknown. We don't know what there might be, but you're not going to find out.
Well, my lord, in those circumstances, the judge found, and we do endorse that conclusion, that it would be in very rare cases, or rare cases, that representations or the gathering of further information will make any difference. And so the question for fairness is whether or not one needs, in every case, to ask the question, to seek the information. And
Well,
our submission, you've got that point. So, my lord, my submission on fairness is that that doesn't require representations to be called for in every case. If you find there has been an error of law, whether at the kind of the macro principle level or on the basis of perverse findings of fact, this court can make the decision for itself. And when you make that decision, if you make that decision, I'm asking you to bear in mind that this is a scheme where there are hundreds of thousands of decisions made in a year, where very few situations where representations will make any difference, and where the system which permits of post-decision representations, where all evidence can be considered, would satisfy fairness, and in a duty sense would provide those for whom it may make a difference ample opportunity to make representations with a view to procuring the decision's modification.
can I ask you something that I think I would like your help on? The authorities we looked at were all cases where the decision maker was making a decision, balancing interests. So, in the case of prisoners, public interest in safety and security, administration of justice, etc., balanced with the undoubted rights of the prisoner. And in the case of Bank Mellat, you have public interest in the proper running of the financial system, avoiding financing of unfortunate matters, balanced with the interest of the bank in not having its operations unfairly suspended, etc. Here we don't have that balancing exercise. In this case, the test, or certainly a primary test, is, in the opinion of the decision maker, is this in the interests of the family? And what I have difficulty with is a suggestion that where that is the express condition, that and where you are dealing with people of full capacity, we're not talking about minors, we're talking about full capacity, not talking about patients, that a decision maker should be forming an opinion about the best interests of that individual and their family without seeking any representations from them. And it seems to me that insofar as there is any uncertainty as to what the test requires in any particular case, when one looks at this statutory requirement, one would, I would have thought, err on the side of seeking representations rather than seek it before you make the decision, rather than only doing it afterwards. There we are. There's a proposition for you to attack.
It's a well-articulated proposition, and I'm sure one that my learned friend would support. It can't be seen in isolation, though, my lord. There are other interests at stake, including the interests of the creditor, the scheme itself. I mean, one has to look at that particular exercise of discretion in the context of the scheme itself, the whole purpose.
Help me where it says that the decision maker takes into account the interests of the creditor.
No, it doesn't say that it takes into account the interest of the creditor, but the whole scheme is set up so that the creditor can get paid, and that its debts can be that the debts can be met, and the ongoing usage can be met. So that can't be divorced from the situation. Secondly,
but that's not something that's not an opinion.
I appreciate it's not
the
an
decision maker has to form. I mean, it's obviously in the interests of the creditor that they should be paid.
Yes, but that's
being paid directly by the government is a lot better than having to enforce it.
Yes.
So it's, as it were, isn't that a given in the scenario? It's not something that has to be weighed, is it?
But Lord, that's the context in which the interests of the benefit claimant has to be considered. They have to consider it in the context of the creditor's interests, and also what are the alternatives to not making the deduction. So
But there's no. Forgive me.
so the Secretary of State is
This
weighing.
is really important. It seems to me this is the absolute core of it, isn't it? And I'm not sure we really looked at the wording in enough detail. If in its opinion it would be in the interest of the family, isn't a balancing factor. It is a condition. It is a requirement, and so it isn't something where you can say, well, we think that the interest of the family are this, and the interest of the creditor is this, and on balance, we think it would be appropriate to make the deduction. You only make it if you are of the opinion it's in the interest of the family. So that's the decision there. That part of the test.
But coming to it, when one is looking at that precise question, one cannot ignore the scheme within which one is operating. No. And, my Lord, the point that you just made, my Lord, that a TPD is better than the enforcement action. So that has to feed into
better for the creditor.
Oh, and the impact on the debtor.
But that is the decision that the decision maker has to make, isn't it?
But the decision maker comes to it knowing that. I mean, these are the findings of the judge below. Knowing that, it will be very rare cases when it won't be in the interest because of the impact that not making the decision will have. So all that's being called for in that context is there something else here which displaces that?
If a decision maker were to say, I take the view that it will only be it's almost always in the interests of the family to do this, and it's only in very rare cases that it isn't. It seems to me if they acted on that basis without considering the individual interests of the family, they would be in breach of all sorts of public law obligations. They'd be treating cases collectively rather than individually, and they'd be applying a policy to an overall policy to each individual, and they wouldn't be applying in each individual case the statutory requirement.
Well, my Lord, one can have a policy which is where it's normally in the interests to have a TPD. That is the approach that is adopted. That's what's reflected in the guidance.
Yes.
The question will be, in a particular case,
yes,
will it not be in their interests?
Yes, and in particular, if you've got a collective position, if you've got a usual position, it makes it all the more important when carrying out this specific exercise in each case. And it's quite clear that it's in each case you must form the opinion that you have proper information. Because otherwise there is a risk that you will simply follow the standard, which you're inviting us to say. You're saying there's almost never any problem with this. Well, that's why you need the information. In
the circumstances of where the judge has found that it's in the very rare case that it will make any difference, given we're dealing with hundreds of thousands of applications, where, as I said yesterday, the delay actually will impact negatively, or could impact negatively, on others, so their interests are relevant, and where we know that the debt is, because we have to assume that the debt is owed, and there is an ongoing usage, so therefore the creditor is saying, well, why should I be providing further services for someone who isn't going to pay for them? In all those circumstances, the question is, does the decision maker have to ask the question to everyone, tell me if you've got anything to say, before they make the decision, or is fairness satisfied by having a mechanism which deals with it afterwards?
Well, as you say, if it's so clear in most cases, how do they form the opinion whether in this case it might be different if they don't ask? I think that's at the end of the day.
Well, they don't ask. They can ask, as in there's nothing in the system which prevents them from asking. The guidance does say, the overview guidance does say you can get on the phone and contact the benefit claimant. So they're not precluded from. It's not saying that it's not possible. But the question is, does fairness demand that in every case the question is asked? That's the test.
Forgive me, I don't think it's just a matter of fairness. It's a matter of how actually do you form an opinion.
Well, my lord, they can form the opinion on the basis of they've got the spreadsheet information. They know what's happened in the background. They know that there's been an ongoing communication and so forth between the benefit claimant and the and the creditor. So it's not something that's happening totally in isolation. And as we talked about yesterday,
but that is an endorsement of just a rubber stamp approach, isn't it? You've got all the information on there which says that they're in arrears and whatever. You just say, here's 50 names, bang, TPD.
But my lord, so the question is, does the system, which allows for, as I've said, the mandatory reconsideration, the de novo appeal and so forth, and does the system to require fairness, does the system to require fairness require that they have to provide, they have the opportunity to provide in advance? My submission is no, because there is a sufficient corrective mechanism available for the very rare cases, the very few cases when it will make a difference. Otherwise, one is imposing, my submission is, an administrative burden on the Secretary of State for hundreds of thousands of cases where it might actually only be of any significance in a very small number.
Just to be clear then, if the decision maker has the schedule,
yes,
which is populated with 50 names and all the boxes filled in, and they look at that and all the boxes look to be filled in appropriately, and they just rubber stamp it and say TPD in those 50 cases, you say that satisfies the requirements of the regulation and fairness.
In the context of what's gone before the spreadsheet, and where there is available the mandatory reconsideration and de novo appeal provisions,
yes.
Then the answer is yes.
Right, thank you.
Because, my lord, for the purposes of a policy challenge, which is what this is, that's what I want to come on to, so the decision in Re A in the Supreme Court, there has to be a material and identifiable number of cases where fairness or Tameside requires it. Of course, my lord, you could identify an individual case where that should have happened. You should have done it there. Therefore, it was unfair to that individual. But when one's making a challenge to an entire scheme, it's not sufficient just to have one case or even a small number of cases, my lord. There has to be a challenge which is on the basis of a material and identifiable number of cases. And I'm going to come to that very shortly, my lord. So if you can just, that in a sense is my answer to your question.
One thing you did mention in the course of it, and I don't know whether or not overnight you were able to find out how long it takes to deal with TPD applications.
I have asked, and I have not been given an answer that I haven't been given an answer, my lord. But if before lunchtime, if at lunchtime I get something, then I will provide it to you.
When you've told us it takes 47 days to do a reconsideration.
My lord, it's 47 days for ESA matters, and I'm getting confirmation that includes any TPD applications, and that's the median. That's the median time. Median time. 47 days, I'm told, from when it's received from the benefit office.
Thank you.
My lord, and I will come back to your point, because my submission will be, even if your proposition is correct in a small number of cases, the question is, does that make this system unfair?
Yes.
For the purposes of a judicial review challenge.
Thank you very much.
But Lord, we need. I've talked a lot about fairness. I just now want to talk briefly about Tameside, and what and what that is all about. Because, my lord, Tameside is it's a species of Wednesbury unreasonableness, and I know you may well be familiar with this, but in case not, it's not about fairness. It's about Wednesbury. It's a feature of Wednesbury unreasonableness, and on the facts of in our case, the judge understood the legal principles that apply, but we say on the facts he erred in law. And my lord, the best place to look at how Tameside is understood and applied is in the Balajagari case itself, where we have no issue with the statement of principles there. My lord, we picked that up at, I think it's 352 in the authorities bundle. At the very bottom, my lord, at paragraph 62, page 352, the Vice President deals with the Tameside duty. And just for you to see what the duty is, it comes from the well-known speech of Lord Diplock in the Tameside case. And the duty is set out in 63. This is the language of Lord Diplock. The Secretary of State is under Tameside duty to take reasonable steps to acquaint himself with the relevant information, and that will be in whatever context. And then it is discussed at paragraph 70, and we endorse, I take no issue with paragraph 70, page 354. The principles were summarised by Mr. Justice Haddon Cave, as it then was in the Plantagenet Alliance case, and it set out as follows. First, the obligation on the decision maker is only to take such steps to inform himself as are reasonable, subject to a Wednesbury challenge. It is for the public body and not the court to decide upon the manner and intensity of inquiry to be undertaken. Thirdly, the court should not intervene merely because it considers that further inquiries would have been sensible or necessary. It should intervene only if no reasonable authority could have been satisfied on the basis of the inquiries made that it possessed the information necessary for its decision. Fourthly, the court should establish what material was before the authority and should only strike down a decision not to make further inquiries if no reasonable authority possessed of the material could suppose that the inquiries they made were sufficient. Fifthly, the principal decision maker must call his own attention to considerations relevant to this duty does not spring from a duty of procedural fairness, rather from the Secretary of State's duty to inform himself as to arrive at a rational conclusion. So those are the principles. So I submit a high test, a high bar to pass for a challenger, because it is a Wednesbury reasonableness test in its classic sense. And in this case, my lord, you know what sources of information there are and the background to which that information can come. In the light of that information and the background to it, my submission is it can't be said that the decision maker does not have all the sufficient information to make a rational decision in any case. But certainly it's sufficient. It can't be said that it's insufficient in every case. or rather that in every case it is irrational not to seek further information from every claimant. The respondent says in their skeleton argument, referring to RA, because this is a systems challenge, that it's enough to establish that in many cases contact is required. And below that, we accept for a systems challenge, but on the facts here, as found by the judge, based on his analysis, it will only be in very rare cases or rare cases where further information might have made a difference. So in those circumstances, although, my lord, you as you posited to me previously, what about the dental plan or some other situation? It might be, in those cases, arguably, well, that would have been useful information for them to have. But that doesn't mean that there are many cases in which that is required. And therefore, albeit you might find on one case, Tameside wasn't satisfied, we're here dealing with an entire system of hundreds of thousands of cases.
Well, is it necessary that there are many cases in which the decision would be different? Or is it simply that there are many cases in which an inquiry might be seen to be helpful, beneficial?
Well, but my lord, that's not the test. As I've, if we go back to the language of the general principles, the court, the third principle, my lord, is the court should not intervene merely because it considers that further inquiries would have been sensible or desirable, which is maybe the more than the very few cases. On your suggestion, that might be more cases than that. It should only intervene. It should intervene only if no reasonable authority could have been satisfied on the basis of inquiries made that it possessed the information necessary for its decision. So, on the judge's findings, there will be very rare cases that it is necessary for its decision. Not every case, not many cases.
Is that what you found?
Well, he's finding that it's very rare cases where a TPD won't be in the interest of the family, therefore that it would make any difference to the outcome. And obviously the purpose of this, the Tameside test, is you need to make a rational decision. Can you make a rational decision without that information?
To me, there's a slight disconnect between the two things, isn't there? Between, can you be satisfied you've got all the information you need, and cases in which it would actually change the decision?
Well, my lord, based on the understanding that it will be in very rare cases that it will make any difference, I think the decision maker can. Oh, my submission is.
But aren't you trying to? But isn't the whole point that you're trying to find those rare cases?
No, my lord.
That's the whole point. I mean, one starts with the proposition, and okay, this is generally a sensible thing. These people have got a debt; they're receiving benefits. It makes sense that that debt is discharged from the benefits. So that is the general proposition. But what we're trying to identify here, the whole point of the exercise under the regulation, as I understand it, is that notwithstanding that general position, which I think the judge accepted, and notwithstanding that, the statute requires the decision maker to form an opinion as to whether in each case it's in the interests of the family. And how do you do that? I thought the obvious answer is you actually make some inquiries, a basic inquiry.
But my lord, the question is, can no reasonable authority be satisfied with the approach that is taken here?
I understand the test, and I understand what you say.
Yep.
And it may be that one will form different views about it.
Well, my lord, my submission is one doesn't need to ask the question of every single claimant, because it is only going to be in very rare cases that the further information will make any difference to the interests of the family test, given what is already known to the decision maker. The decision maker has gone out and got information. They're not making this decision without knowing, based on the spreadsheet, the corrected spreadsheet, which does talk about have you failed 2 payment plans, have you, and so forth. So they know the background, they know and so forth. In those circumstances, it is not necessary to go out to speak to everyone to get the information to make that decision, because there will only.
Let's say it said expressly that you should make the deduction unless the claimant's family had an urgent need to pay for dental care. You'd say, well, it's going to be in very rare cases that they're going to need to pay for dental care, so we don't need to ask.
Because
even though that's an express requirement.
If that was an express requirement, then the court would imply that you are required to ask that question.
Well, here you're required to ask whether it's in their interest.
But in the context where we know that the interest will normally be satisfied by having the TPD. Yes. So, my lord, we say that the judge erred in his findings on Tameside because it was not unreasonable to have the system in place. And then the question becomes, and this is really the ground 3 challenge, which is really the approach to the policy guidance, because actually that's what fed into the order of the judge. And our submission is that if we're correct on fairness and Tameside, then there is no obligation to seek information representations in every case, and so the judge's guidance, the judge's order is wrong and should be quashed. For you to appreciate the general approach to policy challenges, because this is a policy challenge, we need to look at the decision in RA. The judge discusses it at paragraphs 144 to 148, and the judge found that there was what was called category 3 unlawfulness, and I'll show you what that means in the context of RA. The Lord, it's in the authorities bundle behind tab 12. It's a case concerning the guidance of the Home Office for the Child Sex Offender Disclosure Scheme. So obviously a very different scheme, and it's in the context, my lord, of jurisprudence, which has provided a variety of tests to how do you challenge policies. And ultimately, the Supreme Court says you need to go back to the test that was expounded in Gillick. That's the core, and they set out some broad principles. Paragraph 38 is where the judges set out the that view. This is in our view. Gillick sets out the test. So that's page 295 of our bundle. It's best encapsulated in the formulation by Lord Scarman and by adapting Lord Templeman's words. Does the policy in question authorise or approve unlawful conduct by those to whom it is directed? And then they describe different kinds of cases, in particular at paragraph 46, page 298. And they say in broad terms there are 3 types of cases where a policy may be found to be unlawful by reason of what it says or omits to say about the law when giving guidance for others. First is where the policy includes a positive statement of law which is wrong and which will induce a person who follows the policy to breach their legal duty in some way. That's the classic Gillick case. That's not our case. Secondly, with the authority which promulgates the policy does so pursuant to a duty to provide accurate advice about the law but fails to do so. That's not our case. And then category 3 where the authority, even though not under a duty to issue a policy, decides to promulgate one, and in doing so purports in the policy to provide a full account of the legal position, but it fails to achieve that, either because of a specific misstatement of the law or because of an omission, which has the effect that, read as a whole, the policy presents a misleading picture of the true legal position. The audio, and then goes on to say how that applies, and then 47, in a category 3 case, it would not usually be incumbent on the person promulgating the policy to go into full detail about how exactly a discretion should be exercised in every case. And then at paragraph 63, this is where the courts draw the distinction, so page 303, they draw the distinction between the individual case and the system challenge. If it is established that there has in fact been a breach of the duty of fairness in an individual's case, he is of course entitled to redress for the wrong done to him. It does not matter whether the unfairness was produced by application of a policy or occurred for other reasons. But where the question is whether a policy is unlawful, that issue must be addressed looking at whether the policy can be operated in a lawful way or whether it imposes requirements which mean that it can be seen at the outset that a material and identifiable number of cases will be dealt with in an unlawful way. And in our submission, it can't be identified at the outset that the policy guidance here, the decision maker's guidance, the overview guidance, means that it can be seen at the outset that a material and identifiable number of cases will be dealt with in an unlawful way. And in the context here, that the guidance doesn't preclude asking questions, doesn't preclude the decision maker from going out and asking questions. We say it's capable of being lawful, even in those cases where the court may say it would be, in the individual case, unfair or tame-side unreasonable not to have asked the question. Because the overview document says, consider contacting the third party or the customer by telephone for any further information. Another way of looking at it, my lord, building on what you said yesterday, or one of the propositions that you put forward yesterday, you made a suggestion of, well, why can't the utility provider at the bottom of their letter, when they're telling the benefit claimant that they are going to apply for a TPD, why can't they put in there, if you want to make any representations or you want to give any information, you should do so. Here is the address of the DWP and so forth. That was your suggestion yesterday, or one suggestion yesterday. If that was done, that would be something that is done by the supplier. How does that impact on the decision maker's guidance? Well, the decision maker's guidance doesn't prevent that from happening. The decision maker's guidance doesn't say they can't do that. That would provide a solution to your lordship's problem, in that the information could, if it was relevant, be provided. Representations could be provided. The benefit claimant would know what to do and where to go. And the decision maker's guidance wouldn't prevent it from being considered. And my lord, in the decision maker's guidance, which is quoted in the judgment at paragraph 67, page 104 in your bundle, it says 01006, the decision maker must make a decision by considering all the evidence and applying the law, including any relevant case law, to the facts of each case. Where the legislation specifies or implies discretion, the decision maker's judgment must be reasonable, made with unbiased discretion. So if that material is put before the decision maker because it's been encouraged by or prompted by the utility provider, one can easily see, using your lordship's kind of paradigm, that this guidance is capable of lawful implementation. So firstly, we say there's no policy failing here in any event because there's not a material and identifiable number of cases. But secondly, there can be if we're wrong on that, there can be a change to the administrative arrangements at the supplier's end, which would satisfy your lordship's concerns if those are the concerns that you ultimately come to, without any need to change the decision maker's guidance.
Can I just understand how you put this then? If it were the case, as the judge found, that fairness requires that a benefit recipient is given the opportunity to make representations before having his benefits deducted from. Are you saying that nonetheless the policy is not unlawful, even though it does not advise the decision maker that they should seek such representation?
Because the judge found that looking at the policy guidance, it didn't require that. But if there is an administrative change at the supplier's end, which provides that opportunity, and I'm only saying this as a kind of a fallback position, but if the supplier adds that to its letter, then they are provided with the opportunity to make representations and to provide any information, which the decision maker must therefore take into account.
But at the moment, the decision maker knows that that's not done.
The decision maker knows that's not done, but the question for the purposes of RE-A is the policy capable of lawful implementation? Is there something in the policy, if there was something in the policy which said, even if information comes to us, we won't consider it, then that would render it unlawful. The judge found that that wasn't the case. So the question is, if there is...
I could see it if it said, if the policy said you should seek, you should ensure that they're given an opportunity to make representations, unless they were already, that was already done through the utility company. That might be a different matter, but that's not what the policy says.
Well, at the moment, the policy doesn't say any of that. But what the policy does say is you consider all evidence that's presented to you, and it doesn't preclude you from, and definitely doesn't preclude you from taking that into account. The question is, if there is an administrative arrangement at another end which provides that information to you, then we say there is no policy failing because the policy is capable of lawful implementation. That's my secondary submission. My primary submission is we don't get there because you can't there isn't established a material and identifiable number of cases where fairness or tameside requires the question to be asked.
Well, forgive me, we have paragraph 46. If fairness requires that they are asked, then the policy falls down under 46.2, doesn't it? Under 46.3.
No, but my lord, that's in the context of a policy where there is a duty to provide accurate advice about the law. That's a very different scenario, my lord. No one is suggesting that our case falls within a category 2 type case. That's where you'll have a public body which is obliged to set out guidance which says this is our understanding of the law. We're in the category 3 situation. There's no duty to issue any policy. They do decide to promulgate one.
Yes.
But in doing so, there's either a misstatement of the law or an omission, which misrepresents the true legal position. So if here the policy says we will not consider any information that comes to us, that would be one thing.
It omits to say that they should ensure that every claimant is given the opportunity to make representations before they have their benefits subject to a TPD.
Well, it doesn't
No,
say.
that's what the judge found, isn't it?
That's what the judge found. And the judge's finding is in the context, and that is what the judge found. But my lord, if an administrative arrangement was made at the supplier's end where that is done, then
This is your fallback position.
that's my fallback position. Then
But
there
the
is.
primary position. Forgive me. I suppose what I'm trying to understand is where the concept of material identifiable number of cases comes into it in circumstances where, if we were to uphold the judge in saying that fairness required that the benefit recipients were given an opportunity to make representations, I'm just not sure where the material identifiable number of cases comes into it.
Because it's looking at an individual case versus a systemic challenge, as the court sets out in REA at paragraph 63. In an individual case, Ms. Timson or another benefit claimant could say, well, I had something that I really wanted to say. They never gave me the opportunity to make representations. They didn't take into account all relevant information. So they could succeed on a Wednesbury challenge or a fairness challenge. But when one is looking at a system as a whole, the question is, as is set out in paragraph 63, there needs to be material and identifiable number of cases where there will be unlawfulness. Because otherwise, there can be challenges to every policy just because on one occasion or a few occasions unlawfulness will happen. I mean, unlawfulness happens whether all the time in lots of different administrative schemes, but that doesn't mean the scheme itself is unlawful. That's what this is. This is challenging the scheme itself. There have to be material and identifiable number of cases where unlawfulness will arise. So, my lord, those are my submissions on the substantive points. The final point of my appeal is on costs. I'm going to rely on what I set out in my skeleton argument at paragraphs 28 to 30. I appreciate that maybe more may need to be said depending on what you find in this particular case, but essentially we say the judge got it wrong for the reasons set out in the skeleton argument.
Well, your appeal on costs is on the basis that you lose on the substantive.
Yes.
The status quo remains.
Yes.
And you say that
We say that the judge
should not have awarded 100%.
Shouldn't have awarded 100% because there were a whole series of grounds which were argued, and they were severable grounds that were argued. They took up time and they failed. And then you can just see from the respondent's notice there were a whole load of points that the claimant wanted to raise, which or did make and failed. In those circumstances, the only reasonable decision would have been to have made some kind of deduction from costs. Those are my submissions.
Thank you very much.
My Lords, Severn Trent Water is acutely conscious and concerned that many of its customers, in particular those who depend on social security benefits, have difficulty paying their bills. The key factors which give rise to difficulties, or to these difficulties in paying water bills, are the amount paid by way of social security benefits and the amount of water charges. Neither of those are an issue in these proceedings, and each is set following a complex regulated process, much of which is outside the control of my client. But my client is free to act on its concerns by having lower social tariffs and to create schemes and funds to provide assistance to less well-off customers. And as we've explained in paragraph 5.2 of our skeleton argument, it has done so. It has also developed a detailed system for engaging with customers to recover charges, in particular through payment plans, which can be tailored to the customer's circumstances. And it is only when a payment plan cannot be agreed, or has been agreed and then not implemented, that my client considers applying for TPDs as an alternative to other enforcement action. That is what is required of all fuel and water utilities by the joint statement of intent at page 1 of the supplementary bundle. Severn Trent Water contributed to the proceedings in the court below by providing detailed evidence covering its dealings with the claimant, but also, more importantly, its processes and procedures for debt management. And it explained to the court, as a matter of fact, how it would only apply for TPDs where it had engaged with a customer over a lengthy period and consensual methods of debt recovery had failed. And it also explained why, in its view, it was in the interests of its customers, who had not, for whatever reason, agreed to or implemented payment plans to address their debt, to have limited deductions made from their benefits to pay for ongoing usage and to repay the money that they owed. And the witness statement of Mr. Grice is page 129 of the supplementary bundle, and I refer to it at this stage only to rebut the submission in my learned friend Mr. Richards' supplementary skeleton argument, paragraph 15, that my client had not provided evidence in support of its submissions to the administrative court. Indeed, we say that Severn Trent Water's evidence was a significant contributor to the judge's findings of fact, insofar as relevant to the interests of claimants. And those findings of fact we submit, and we've submitted in paragraph 9 of our skeleton argument, are significant and cannot be reopened on this appeal. I'll take you to some of the principal ones in a moment. There is criticism in the claimant's main skeleton and indeed her supplementary skeleton of the judge's findings, but it's not suggested at any stage that these findings were based on no evidence or that they were perverse in the sense that they were findings that no reasonable judge could have reached. So there is no attempt, there has been no attempt in either of my learned friends' skeletons to satisfy the normal standards for appealing against findings of fact, whether findings of primary fact, evaluation of those facts, or inferences to be drawn from them. What findings of fact do I particularly rely upon? Can I start with page 109 of the core bundle, paragraph 82 of the judgment, where the judge summarises the effect of the witness evidence before him. Applications for TPDs are only made where a claimant is in arrears and where other efforts to take steps to reduce the arrears have failed, only made when there's no dispute as to the debt and where the application for a TPD is an alternative to court or other enforcement action. On page 111, between 93 and 98, on the next page, there's a series of findings, not just as to how Severn Trent Water deals with its customers, but also that those reflect the general approach of water and fuel suppliers. And in particular, we rely upon paragraph 96, TPDs being a last resort, and paragraph 98, the warning being given to customers that Severn Trent Water will apply for TPDs if they do not engage and seek to enter into a satisfactory payment plan.
Can I just ask this question? Just try and understand what it is that the judge found about TPD as an alternative to court or other enforcement action. We've got those words in paragraph 82, but they rather beg a question about cases such as those relied on by the respondent, where the claimant, benefit claimant, has no assets and no income. And in 95 of the judgment, the judge records Mr. Grice's evidence that in general Severn Trent Water doesn't take debt recovery proceedings against a person in that position. So it's not a finding, and I don't think it was the evidence, is it, that a person in that position is at risk of debt recovery proceedings?
That's right, my lord, and we were quite frank about that.
Yes,
but what the judge is careful to say at a number of points in his judgment is that even though a claimant in the position of the respondent is not at significant risk of being sued by Severn Trent Water, there are other types of enforcement action, including selling on the debt to an enforcement agency, passing on for somebody else to enforce who may not have the same compunction and the same regard as Severn Trent Water does. And it was a key part of the judge's reasoning that even if you're not likely to be sued, other potentially unpleasant types of enforcement action could follow.
So when the spreadsheet asks the question, will enforcement action be taken if deductions from benefit are not made? That's the current spreadsheet question. I think I'm probably, it's the same question for water and fuel. And the answer is yes. That could mean any one of a range of enforcement steps.
Yes.
And in a case where the paragraph 95 customer was concerned, it could mean selling the debt.
It could do.
It doesn't mean disconnection.
No. It
Selling
never
the
means
debt,
disconnection.
selling the debt isn't enforcement.
Well, it is a means of addressing the debt. We've characterised it as there being a range of different types of enforcement action.
But you assuming you don't fill in this column to say yes simply because you're going to sell the debt.
Well, we fill it in as we've got to the point where we have no option but to take one of a suite of enforcement measures. For some claimants, at certain times, yes, we are unlikely to take proceedings against them, as Mr. Grice indicated. Other things that we may do.
Like what?
Well,
You don't understand what enforcement action you can take in relation to a debt until you've obtained a judgment.
well the
There's law about that.
sorry, no,
There's sorry, forgive me. You can't take enforcement action against a debt until you've got a judgment, can you?
well, we don't understand that's what that technical meaning of enforcement action is what's required by the spreadsheet, because that would mean that we could only apply for a TPD once we had a judgment against somebody. So
Enforcement action, I can see you might say enforcement action might be taking legal proceedings, but short of that, I can't think what anyone can do with a debt that could properly be described as enforcement other than suing for it. And there used to be things that were done for debts, and they were outlawed.
So, well, there is always a possibility, and depending on the claimant's circumstances as they are from time to time, there's a possibility that we will sue for the debt and how much the debt is and so forth. But there is also a possibility of passing the debt on to somebody else who may sue for it.
Forgive me, books of debts are commercially sold all the time, all over the world, and to some extent led to a very substantial financial crisis. Certainly, as far as I'm concerned, as a commercial lawyer, the sale of a debt is not enforcement of the debt, and isn't close to enforcement of the debt. So I'm not sure how you can say that is enforcement.
Well, look, so far as the claimant is concerned, it is enforcement because rather than Severn Trent taking action against them, there will be the debt recovery agency taking action against them. And as the judge indicated, the mere step of selling on the debt results in administrative charges, in the debt increasing.
Well, forgive me, debt recovery agencies don't usually buy the debts, do they? Debt recovery agencies are usually recovering on behalf of the principal for a commission. If the debt is sold on, what the new creditor does is up to them. They may enforce it they may not. Presumably they will, otherwise they won't enforce it. But it's not enforcement action to sell it to a third party.
Well, in some cases, we will simply use an agency to assist in recovery of a debt. In other circumstances, there will be a selling on, no doubt. But
what I'm quite worried about here, make it plain, I'm quite worried about it if it's been suggested you're representing to the department that you will take enforcement action if what you mean by that is that you will sell the debt.
Well, what we mean by that is that we've got to the point where we haven't been able to agree a consensual recovery plan, so we've got to the enforcement stage, and that may involve one of a number of different courses of action. This is all set out in Mr. Grice's witness statement. And it is right to say to the department that we've got to the enforcement stage and that is the alternative to TPDs. We may enforce ourselves, it may be somebody else enforcing on our behalf or on their own behalf having acquired the debt. There's a range of different options.
My understanding is, and presumably you know this, your client, I mean by that, knows this only too well, is what is being considered here by the department is whether, in the department's opinion, it is in the interests of the family to make a TPD. And so in making that decision, plainly, and it seems that probably the primary information they have is what is on the sheet. So if you're representing to them that you are going to take enforcement action, it's important that the department understands what you mean by that. Because plainly what's in the interests of the family very much depends on whether you are genuinely going to take enforcement action.
Well, Lord,
it doesn't say may you take it or will you consider it. It says will it be taken.
In the judge's view, it didn't matter, so far as the interests of the family were concerned, whether the enforcement action was being taken to court, whether it was the debt increasing because it's passed on to an agency to enforce. He regarded all of those possible consequences as detrimental and adverse to the interests of the family. So my Lord, of course, I accept the department needs the information from us, but it is, so far as the interests of the claimant are concerned, this was all argued out before the judge, and he accepted at a number of points in his judgment that simply having the debt passed on to someone else, debt increasing, other alternatives to legal action by Severn Trent Water or another utility were all detrimental and adverse to the interests of the family.
Could I just ask, does Mr. Grice deal with selling the debt as opposed to employing a debt recovery agency to manage the debt? Because if he does, I can't find it. And that's why I'm asking for help.
My Lord, can I take instructions on that?
Yes.
I see what you mean. Paragraph 26.3, he refers to outsourcing the debt.
Yes, but he means getting a third-party debt collection agency to manage it. It doesn't mean selling it.
Well, let me take instructions on that. I take my Lord's point.
So obviously, if you're selling the debt, you can't get a third-party deduction to pay a debt that is now owed to somebody else.
My Lord, I may have misspoke when I said sold the debt rather than passed it on to the agency. But I will take instructions. So there are significant findings of fact in paragraphs 93 to 98. In the group of paragraphs which Mr. Sheldon took you to, starting at 175 on page 132 of the core bundle, 178, 179, reference to the vast majority of cases, and 194, the rare case when it will not be in the interests of the claimant for a TPD to be made. Paragraph 211 on page 138 lengthy contact with claimants and given them the opportunity to provide information before a TPD request is made. And 257 on page 149, the top of 149, the judge says at least since December 2021, the scheme is designed to ensure that claimants are notified in advance before a TPD is imposed upon them. This means that if they are minded to do so, they can contact the department of their own volition to make representations or provide relevant information. Now, I know there's been discussion about, well, is that realistic? But this is a finding of fact by the judge. Claimants are in regular contact with the DWP. The idea that they can't contact the DWP to make representations about third-party deductions, well, it's not a perverse finding, which the judge has made, and that is a significant safeguard in the rare case where there may be something to say. We know that in the vast majority of cases, claimants don't have something to say because the numbers who take up the opportunity for mandatory reconsideration on the evidence are very small. It's a rare step. And we say, well, though in those rare cases, that can be picked up by representations made in advance. Sorry. No. In advance, and then you've got the ex post facto remedies as well. So the findings of the judge as to what happens in the generality of cases has one important consequence in our submission, quite apart from whether any challenge can be made to them, which is that the facts of the claimant's case, which took up a considerable time before the judge, are no longer of such, if any, significance. They were only ever illustrative of what might happen in the generality of cases, because this was never a challenge to the particular deduction decisions in the claimant's case. In paragraph 10 of our skeleton argument, we have sought to defend the judge's findings in the section from 175 to 183. That begins on page 132 of the judgment. And in particular, his finding at paragraph 180, where he expressed considerable unease about the claimant's argument on financial autonomy. And he says the claimant's point is ultimately that she does not need to worry about paying a debt that she accepts she owes. or about paying for future usage, because she can get away scot-free if she ignores her financial obligations to the utility companies. And we've seen the response from the claimant in the supplementary skeleton, paragraph 12, where she says that Severn Trent Water had misunderstood her position, and her position was never that she didn't want to pay or thought she thought it was in her interest to not pay the debt at all. But she says it was in her interest to have a more flexible arrangement, a payment plan with Severn Trent Water, which could be, or E.ON as it was, which could be flexible as to date, flexible as to amount, flexible as to missing the odd payment now and again. Well, that is not what her central submission was to the judge, and he understood it and rejected it. But the new position in our submission simply doesn't make sense, because the TPD is only applied for once the payment plan options have failed. The claimant ended up, after the litigation started, entering into a payment plan, one of our standard PPC plans, at a fairly low rate. She hadn't previously engaged with our attempts to agree a payment plan with her, and therefore the plan was set at a standard rate. It wasn't met. The TPD was applied for. But that option was always available, is always available to a claimant to establish that they can't pay the payment plan at the standard rate, and Mr. Grice explains all of this, and a lower rate can be agreed.
The schedule seems to suggest that there have to have been 2 payment plan failures, is that right?
Yes, and there had been a number of failures in the claimant's case. The most recent one was we'd set a standard plan because she failed to respond to our letters on it, and that was missed.
May I ask a very basic question? It may be in the evidence, I haven't spotted it. How do you know somebody's on benefits?
That is a good question, my lord. I imagine because either they tell us in our various interactions with them, and there are extensive interactions before we ever get to the stage of applying for TPD, or we know from previous dealings with them that they at least have been on benefits, and then it's an obvious question to ask if they still are. But of course there are, and mistakes are made. Applications for TPDs are made in respect of people who it turns out aren't on benefits anymore, and therefore they're rejected. That can happen.
Right.
So my lord, the new position doesn't make sense. It's all accommodated for in the system whereby payment plans can be agreed before any application for TPDs is met. And there really isn't any difference in substance between the argument about which the judge was extremely uneasy, that a claimant on benefits who may not be an attractive target for enforcement litigation can simply, that it's in their interest simply not to pay. There's very little difference in substance between that and the argument rejected by the judge at paragraph 186, which is that there's some temporary reason why the claimant, or some particular expense which the claimant wishes to meet rather than to pay for water or electricity, whatever it is. And we say the judge was entirely right to conclude that line of argument is not consistent with the statutory scheme, which establishes priority debts, the obligation to pay priority debts, and you'll have seen our submission as to the significance of the words "has failed to budget for water charges." So we say paragraph 186 is consistent with what the judge said earlier and is entirely unexceptional. Well, as I'm reaching the end of my allotted time, give me a moment. The claimant says that our submission is inconsistent with the new regulations which take ongoing electricity fuel usage out of the normal scheme for deductions, in that they subject them to a consent test rather than an interest of the family test. That argument was made to the judge based on the initial temporary regulations. We say that that doesn't change the position. There's been a policy decision in the light of the very substantial increases in costs of electricity and gas to make this subject to consent. No doubt, because in very many cases the 25% threshold of consent is necessary in any event would be reached for ongoing fuel costs. We made our submission on the judge's hypothetical cases in our skeleton argument, paragraph 15. Yes, if look at his third hypothetical case, if the claimant is willing to engage with a payment plan arrangement, that may be a reason not to grant the TPD, but there's no need to consult in advance about that, because if they do enter into a payment plan, the TPD application will be withdrawn. And my final point, Lord, is one that goes to the substance of the case, or the substance of Mr. Sheldon's principal argument. And it's this, that as we understand it, as there's no submission that the ex post facto remedies, the reconsideration, the de novo appeal, are insufficient to provide to correct any errors that were made first time round, take everything into consideration and reach a fair decision. That the real point about fairness, and why fairness is said to require consultation in advance, is the detriment that may occur to a claimant in the meantime if deductions are implemented without them being consulted prior to that. But there are a number of points to be made as to why that is not shouldn't be considered to be a substantial detriment. The amount of benefits which may be deducted is capped, as you know. The money is not being confiscated in some way, but is going to discharge liabilities which the claimant will otherwise have in the interim. They are protected from enforcement action in the interim, any kind of enforcement action. And one of the most common reasons to dispute a TPD, that there's no debt owed at all, is catered for in the defendant's procedures, where they will suspend the TPD until that is resolved. So the detriment in the very limited number of cases where there may have been something useful to say is very small in our submission, and doesn't call for the approach to fairness which the judge considered was necessary. Those are my submissions.
Can I ask one question? Why is your client concerned about the department asking your customers about whether they should be subject to deduction?
So my client is concerned for two reasons. First of all, because it, as Mr. Sheldon submitted, it introduces delay into the system for all affected claimants, when only a very small number would have relevant points to make and would wish to make them. And I just in answer to one of the questions put to Mr. Sheldon yesterday, our experience of the deduction system is that decisions are made very quickly indeed. There's some evidence in Mr. Grice's statement on the claimant's case. I'll just give you this. Paragraphs 54 to 55 of Mr. Grice. Application made on 10th of September 2019, deduction started on the 18th of September. So it introduces delay, but the second reason why we're concerned is the respondent's notice points that if the claimant is right and the decision maker really does have to consider all of the other items of expenditure that they regard as more important and then balance that against what type of action might be taken against them and what the consequences of that might be, that will introduce significant delay into the system for what may start to be a small number of cases, but if that is really to be the position, it may be an ever-increasing number of cases.
I would imagine that there might be a concern that that whole process or some of it might be outsourced to your client.
Well, I mean, my
It would be a natural
client
concern.
would,
It's not a criticism. The department would be looking to ensure that it spends as little as possible, and the scheme as it stands involves that sort of process.
yes. Well, my client, I believe, would say that they already collect a lot of the information which might be relevant to that in their dealings and their negotiations about payment plans and so forth. But you're quite right, there could be a greater burden placed upon them in terms of explaining the facts of individual cases to the department.
Thanks very much.
Well, it might only mean, mightn't it, that you change your form a little bit that's on page 12 of the supplementary bundle, where you're required by the joint statement of intent to ask, to tell the department of any other information which may be relevant to support this application for Water Direct, e.g. family and or household background and circumstances.
Yes.
If you were asked to provide information about what they told you about all that, and then that could go onto the spreadsheet,
Yes.
that might be all that would be required. Is there a reason why you couldn't do that?
Well, so look, the evidence was that the form had not been in use for a number of years.
Yeah.
At least for the majority of water companies, and the A spreadsheet had been used instead. Mr. Grice explains this. Could we provide the department with more information? Well, of course we have files, we have notes of our interactions with claimants. In theory, we could, but one is rather opening something of a Pandora's box for the decision maker in terms of collecting all of this information and then reaching a decision in writing or based on written representations. When really, in a case where this really matters, these are the sorts of issues which the first-tier tribunal, which a proper evidence-gathering body ought to be looking at. We say that just wasn't the intention of the regulations.
Thank you.
Thank you very much, Mr. Copple. Yes, Richards.
My Lords, the underlying issue in the appeal poses a relatively short and straightforward question. Does fairness and or the Tameside duty of sufficient inquiry require, within this particular statutory framework, the Secretary of State to seek information from benefit recipients before deciding that third-party deductions are in their individual interests? We say the answer to that is an unequivocal yes, for the reasons given by the judge, essentially, save that he took an overly narrow approach to the question of what might factor into the assessment of interests that was not warranted and is not warranted by the statutory language. In terms of the structure of my submissions, I'm just going to say a little to start with about the position of the respondent and her experiences. Then make submissions about the statutory framework and the statutory language. Then look at the decision-making processes of the Secretary of State for Work and Pensions and the kind of information that he has before him. I'll then develop submissions in relation to the Secretary of State's grounds of appeal 1 to 4, then deal with our respondent's notice arguments before turning finally to the relevance of the amendments to the statutory framework made through the 2023 regulations, and if time permits, very briefly, the issue relating to costs. So dealing first of all with the position of the respondent, Ms Timson, she has filed within these proceedings 3 witness statements. I hope the court has had the opportunity to read those. I won't take you through them in the interests of time, but I might just give the references again. So it's supplemental bundle, tab 2, page 17 is the first statement, tab 4, page 31, the second statement, and tab 18, page 218, the third statement. And you will have seen from those statements, she is a former police officer who had to take medical retirement. She has significantly disabling mental health difficulties, severe depression, anxiety, extreme social anxiety, etc., plus various physical health problems. That's rendered her dependent upon means-tested benefit, and the particular benefit, principal benefit she receives is the employment and support allowance. That's a subsistence benefit paid to those whose ability to work is affected by disability or illness. Her disabilities are also recognised by receipt of components of the Personal Independence Payment, the PIP, and that's payable to those whose ability to carry out their daily living activities is severely limited by physical or mental condition. Important to note, the purpose of those additional payments are to help with the additional expenditure that arises from physical or mental health. They are not designed as a means to enable people to pay for the normal expenses of daily living. My learned friend for the Secretary of State made repeated references to the fact that the maximum that TPDs can amount to is 25% of certain benefits, and that claimants will retain, he asserted repeatedly, no less than 75% of the relevant benefits. Now that's correct as a matter of fact, but if the implication is that no benefit recipient should ever struggle or be disadvantaged in meeting their daily living costs, that cannot be right. We've set out certain figures in our skeleton argument about benefit levels. The benefit levels are, and I don't think this is me giving evidence, they are very challenging to live on. The standard rate for a single person would be £77 per week. It can be as low as £30.53 per person per week for a couple where one is under 18, and those figures are in our skeleton. Where a benefit claimant receives additional amounts to the subsistence benefits, that is usually because they are recognised as having additional costs, for example, children, and so there may be some children-related benefits, or, as with Ms Timson, disability-related benefits. Again, we've set this out in our skeleton, but there will be many cases in which a person's housing costs, council tax costs, are not met in full by the allowances that they receive. So some of a very already challenging subsistence benefit may be swallowed up by them having to make good that shortfall in relation to their housing costs, and that has been the position for Ms Timson. So however well claimant benefits may budget, however conscientious they may be, it may at times simply not be possible for them to meet all reasonable household expenses and needs and obligations, especially in times of personal crisis, or in times where the cost of living is increasing, but benefits are not increasing commensurately. And there are a couple of authorities, we have again referenced them in a footnote in our skeleton, but if I can just take you to the passages shortly. So if the court has the authorities bundle, this is tab 20, it's a judgment that starts on page 576 of the bundle, case called T in the Secretary of State for Work and Pensions. I need only, for the purposes of this submission, refer you to page 597, paragraph 55, where the Court of Appeal observe significantly the judge recognised that in absolute terms the amounts paid by way of legacy benefits were low, and it was obvious that any person required to rely on that level of income replacement provided by legacy benefits would suffer hardship and would find it more difficult to meet basic living expenses during the pandemic. The reference to the pandemic is simply because this was a challenge to a decision of the Secretary of State to increase an element of universal credit, but not to provide an equivalent increase in relation to legacy benefits. But it's that general statement at the beginning of paragraph 55 that I refer to. And then secondly, if your lordships go to tab 16 of the authorities bundle, starts on page 418, decision of the Supreme Court in a case called DA and the Secretary of State for Work and Pensions. This was about the benefits cap. Again, it's not the meat of the case that's relevant, but if the court turns to page 430, very bottom of the page, paragraph 33, there's a rhetorical question: does the revised cap inflict poverty on those subject to it? The answer is hotly contested. And then this: but since the government cannot sensibly argue that the computation of welfare benefits is intended to provide a family with more than it needs, it follows that a reduction of those benefits will provide it with less than it needs. And then there's reference to a speech by the then Prime Minister about the effect of welfare benefits to push people's incomes just above the poverty line, follows the substantial reduction and then pulls their incomes well down below the poverty line. So they're really just a judicial reflection of the broad point that I've sought to make. And so a non-consensual deduction, which may remove up to 25% of a claimant's subsistence allowance, may present significant practical challenges for a benefit recipient. In the respondent's case, she did fall into debt. Her debts did include arrears of utility bills. That is emphatically not because she has ever taken the view that paying for her utilities is unimportant, but because of the practical reality of dependence on welfare benefits means it's a constant struggle to manage. Now, in terms of the history of the deductions, in her case, I'm not going to go through the detail of them. You have them in her witness statements. You will have seen that her particular experiences have included third-party deductions being made erroneously, leaving aside the question of the principle in relation to her interests. And the reference, or one of the references there, is in the supplemental bundle, tab 2, page 19, paragraph 9e. There's no need to turn it up. But her experiences include deductions continuing after arrears have been paid off and her account closed and she's no longer a customer, deductions credited to the wrong account or for the wrong amount, and a faulty meter, for which resulted in her being overcharged for her electricity. In terms of the impact of the deductions on her, and again, this is illustrative because, as my learned friends correctly point out, this is a systems challenge and not an individual challenge. But again, as detailed in her statements, the impact of deductions has meant she has sometimes been unable to buy food or pay her full rent. And the reference there is supplemental bundle tab 2, page 18, paragraph 7. It's had a significant emotional and financial impact on her. That's the same reference. And I invite the court's attention, again, not now, but in terms of any further reading or rereading, to paragraphs 37 to 51 of her statement, her first statement, so pages 24 to 26 of the supplemental bundle, where she talks about the impact on her mental health in terms of stress and suicidal feelings. And she talks about the practical difficulties of having no buffer, so being unable to, for example, pay for transport to medical appointments, and talks about what has seemed to her to be the demeaning and stressful impact. And that's paragraphs 44, 46 and 47 in particular. And then her second statement, tab 4, page 32, paragraph 7, talks about the importance from her perspective of financial control and of having a degree of flexibility. Just to complete the factual position, the current arrangements were agreed in the latter part of 2021, where she agreed with Severn Trent Water to pay a specific amount in respect of usage and arrears. The amount in relation to arrears is £1 a month, and in relation to Eon, it was the same. Important to note that under those arrangements, only entered into after the proceedings were issued, after the Secretary of State had superseded his earlier decisions. The amount which the respondent is paying is less than, and even what might be regarded as small amounts, are significant amounts for her. So significantly less than she would be paying under the deduction scheme. Because as we'll come to, a feature of the deduction scheme is that the amount is fixed. Further, because she's paying by standing order, that gives her the flexibility to skip individual payments or vary the payment date or cancel the payment altogether if there is a pressing need that arises in a particular month. And she has used that flexibility as we've set out in the statement. It's right also to note that Ms Timson's experience is that she did raise objections to the third-party deductions, which were not treated as a request for revision, which is the actual statutory term. Mandatory reconsideration is the parlance that's used, but revision is the statutory language. She was told she had to approach the utility providers. Right to note that the Secretary of State accepts that that was the wrong approach, but that's the approach that she was met with. Against that background then, in relation to the respondent's position, I turn to the statutory framework. Your Lordships have already seen the terms of the regulations. Regulation 35, the use of the word may, so it's a discretion, a power, not a duty to make the deduction. Your Lordships have also seen the Schedule 9, paragraph 1 definition of what's meant by family. So where there is, as in the respondent's case, a sole claimant, it's the interests of that individual claimant. But where there is a family, it includes what effectively comprises the benefit household, so partner and children ordinarily. And then you'll have seen the language of paragraph 6 in relation to fuel. So the Secretary of State, if in its opinion it would be in the interests of the family to do so. And then the language of paragraph 7 in relation to water, only if the Secretary of State is satisfied that it would be in the interests of the family to make the determination. There is a slight difference in the wording, but nothing in my respectful submission turns on that difference. The original regulations had the interest requirements in relation to fuel, but not the interest requirement in relation to water. And the regulations as originally enacted are in the authorities bundle. I don't need to ask you to turn it up, but it's tab 4. So starting on page 64 of the authorities bundle. The requirement that any third-party deductions in relation to water should be in the interests of the claimant was a subsequent amendment to the regulations. I can't remember the precise date, but it's certainly been the position for a period of time. And then just as a point of detail, Mr Sheldon gave you a figure for the rate of personal allowance of £73.10. As I understand it, the current figure is £84.80. Again, nothing turns on that, but just in the interests of accuracy. there are 5 features of the legislative framework that I seek to emphasise. The first, as already alluded to, is that any deduction is a discretion, not a duty. So it requires a conscious decision on the part of the Secretary of State, not something that can be automatically triggered or in my respectful submission, as legally rubber stamped. The second, again, as already alluded to, is that the deductions can only be made at a fixed and relatively high, we would say, rate. The rate is set in the regulations. That means that alternative debt repayment mechanisms may leave a claimant with more income, as is currently the position for Ms. Timson. The third and most important feature of the statutory scheme is that the discretion can be exercised in the case of utilities, fuel, water, and certain other debts, only where making the deduction is found to be, determined to be, in the claimant's interests. And regarding that interest requirement, that's not just a mandatory relevant consideration, that is a precondition to the exercise of the power. If the Secretary of State is not so satisfied, it is not lawful to make the deduction. It's the Secretary of State and not the utility provider who is required under the regulations to form an opinion as to whether it's in the claimant's interests for the deduction to be made. And so whilst it would be lawful for the Secretary of State to consider a utility provider's view that it's in the claimant's interests, that cannot be a substitute for it being a proper exercise of discretion and decision-making on the part of the Secretary of State. The very fact that this requirement exists in the regulations is, we would respectfully submit, an indicator in itself that the legislature expected there to be more than an insignificant number of cases where deductions would not be in a claimant's interests. Otherwise, the condition would be OTOs. And one feature of the legislative scheme which may not have become apparent yet in the course of the oral submissions is that there are some types of debt for which the statutory framework imposes no interests requirement. And I'll provide you after lunch with copies of the relevant regulations. They are referred to in our skeleton argument, but they were not, or they were overlooked when the authorities bundle was being compiled, for which my apologies. But Schedule 9B to the 1987 regulations, and then a separate set of income support regulations, introduce and contain a power to make deductions for a number of types of liability without there being any requirement that it be in the individual claimant's interests. Examples of that are fines and child maintenance. There are some others as well. So that's an issue I'll come back to, if I may, at a later stage in terms of giving you the actual regulations. But it is a matter of, we would suggest, some significance, that the legislature has specifically identified that there will be types of debt where a deduction is permissible only where it is in the interest of the individual claimant. Fourth broad feature of the legislative scheme, interests, is a broad term. There is no definition of interests in the regulations. There are no presumptions introduced in the regulations. It's a term that should be given its normal, natural meaning. It's not limited in any sense. The claimant submissions, the appellant submissions, and to some extent the judges, the findings that are the subject of the respondent's notice, look at interests in a narrow way, in a one-sided way, essentially, looking at what might be the advantage of making a deduction, but without ever exploring the disadvantages or downsides of making the deduction. We say there's nothing in the legislation or in the regulations to suggest that any kind of narrow approach should be taken to an understanding of what is interests. And then the fifth broad point, which really reflects observations from the court yesterday, is the reference to family, which means that the Secretary of State is obliged to look beyond the interests of the direct welfare recipient and debtor to consider whether there is a household or whether other members of the family who fall within the definition, to consider whether their interests are furthered or not by the imposition of the deductions. And of course, one can quite easily envisage a scenario in which it might be said to be in the interests of children for deductions to be made. And I'm going to take a slightly ludicrous example, if I may, to illustrate the point. But you have a parent with an addiction to gambling who would rather spend benefits on gambling than pay their energy provider, with a risk of disconnection and the like. Disconnections are actually, as a matter of practice, something that's unlikely to eventuate if there are children in the household. But what one can, in principle at least, envisage that kind of scenario. But equally, there may be scenarios in which the loss of that amount of money by way of deductions to pay historic arrears where realistically it may be unlikely that the individual is going to be taken to court. And counterbalanced against that is a child's need for clothing, for food, for urgent dental treatment. And all those are capable of being encompassed within the term interests of the family within the regulations.
I just say one fact feature which I think I'm not sure has focused on is the very fact that the amount is capped demonstrates that it's inherent in the legislation, that it's accepted that the debts in question are not necessarily priority debts, and that there is an amount which the benefit recipient must have for other things, even at the expense of not paying for these debts.
Yes.
And so to say that in some way there is a presumption that these debts must be paid, it runs contrary to that feature of the legislation.
Well, I would respectfully endorse that. I would just also, perhaps convenient to deal with a submission that's made about the provision in the regulations which gives a hierarchy of debts. But that, in my respectful submission, is nothing to the point. We have dealt with it in our skeleton argument, so I'll take it briefly. The fact that the regulations provide a hierarchy of debts in terms of third-party deductions is there to provide a practical way for the decision-maker, if satisfied that it's an appropriate case for a range of deductions to be made, to decide which deductions take precedence. Does housing take precedence over water, or whichever way round it might be? It says nothing about the position in terms of the interests of the family, of what else they might need to spend their money on in order to meet basic living expenses, food, clothing, travel, and the like. And then made the submission a few moments ago about the importance of the interests requirement. It is, as my lords have already noted, it's focused upon the individual. That's quite clear from the statutory language. It's not about interests of benefit claimants or recipients of a certain type of benefit as a class or cohort. And there is nothing in there, as my lord observed, about the interests of the creditor, the utility company. And again, I think, as my lord said in dialogue with Mr. Sheldon, it may be a given that an advantage or a consequence of making deductions is that the utility company receives some of the money which is owed to it. But there isn't a balancing exercise that's set out in the regulations. There is this statutory precondition that the deduction must be in the interest of the claimant. And if it isn't, then whatever the advantages to the utility company of the deduction being made, it cannot lawfully be My Lords, if I can turn next then to aspects of the decision-making processes of the Secretary of State for Work and Pensions in relation to these types of decisions. And I do so in particular because Mr. Sheldon places substantial weight on what he says is both the pre-engagement process and then the information that will be available to the Secretary of State when his decision makers take their decisions. So the evidence before the court below, as Mr. Coppell has already indicated, was that the majority of applications are made by spreadsheet. I will want to look at the joint statement of intent and the appendices to those, but made by spreadsheet. And at the time the decisions in relation to the respondent were made, the spreadsheet didn't even give any way for a supplier to indicate whether the claimant did or didn't know that the application was being made. Now that has been amended, and so there is now a box to ask whether the claimant knows that the application is being made. Mr. Sheldon's submission was that if the claimant's not been told, the Secretary of State won't make the deductions. I'm not sure that's actually set out in the evidence anywhere, but no doubt if I'm wrong about that, Mr. Sheldon will correct me in due course. There's no evidence to suggest that the Secretary of State undertakes any checks as to the correctness or otherwise of the information contained in the spreadsheet, including the assertion that the claimant's been notified. And there's no requirement on a utility company to, for example, set out what response, if any, has been made by the benefit recipient to any overtures that they have made. And if one looks at the spreadsheet, and I'm just going to take the one from page 216 by way of example, and so it's the one with the orange colouring. The vast majority of the information is really just the information that would, as a matter of mechanics, be required for the Secretary of State to implement deductions, rather than going to the statutory question of whether those deductions are in the claimant's interests. And then those first four questions, which are in the different colour on the top left-hand corner, they will obviously provide some information to the Secretary of State about the extent to which other avenues have been explored, although for reasons that would have been apparent from my Lord's questions to Mr. Coppell, the issue in relation to enforcement action is potentially rather opaque. But then we just have the question about whether there's any other relevant information. And that's left to the utility provider to complete as they do or don't see fit. That's not a substitute, in my respectful submission, for obtaining information that's focused on the statutory test and obtaining it from the source most likely to be able to provide such information, the claimant themselves.
Once I understand Mr. Sheldon's position, he says it meets relevant requirements of fairness and Thameside, even if all that was done was this was rubber stamped.
Yes, and that cannot be right. That would be a fettering of discretion, if nothing else, because it simply doesn't provide the information that would enable the Secretary of State to determine if the deductions are in the claimant's interests. I don't suggest that this information shouldn't be provided. It's some of the data that the Secretary of State will need, but it cannot possibly go far enough to enable the Secretary of State to answer the statutory question. And rubber stamping would be unlawful for reasons not simply of unfairness or Thameside, but because it would be a fettering of discretion.
Well, it would actually not be making a decision.
No, absolutely.
At all, without getting to whether it was made fairly. It hadn't been made.
Yes. Or it had been made on an automated basis in which the statutory question precondition hadn't properly been asked or answered. And although the focus of the claim obviously is on fairness and Thameside, the thrust of the evidence, and I'll show you a couple of pieces of the defendant's own, appellant's own evidence in due course, but the thrust of the evidence really it was that the Secretary of State does no more, or his decision makers do no more than look at this and rubber stamp.
Well, the regulation only arises if there is a debt in relation to one of these debt types of utility debt, and with just a very little more information, it's hard to see on the Secretary of State's case what in the opinion of the Secretary of State is in the family's interest adds the basic factual matrix that there is a debt owed to a utilities company by a customer who happens to be on benefits.
Yes, well, that would appear to be the general approach of the Secretary of State. There is a debt, it's being sought. The claimant's been notified.
It is to be assumed to be in their interest to pay the debt.
Yes, but that's not a legitimate approach to the requirements of the legislation. If I can invite the court's attention then to the joint statement of intent, having looked at the spreadsheet. So it's in the supplemental bundle tab 1, page 4. Now this is a statement of intent agreed as between the Secretary of State for Work and Pensions and then licensed fuel suppliers and water suppliers. If you turn to the substance of it, pages 5 onwards, there's actually no reference to interests of the individual until we get to page 7, paragraph 22, which is looking at continuation of third-party deductions. And then we see set out in paragraph 22, it talks about how you can continue for ongoing charges alone where the decision maker determines it's in the interest of the customer and their family. You'll note paragraph 25 refers to the decision maker considering all the circumstances of the case, including customer's ability and opportunity to budget, and any representations from the supplier. No reference, in fact, to representations from the claimant. But in any event, it's the letters at Annex A, or the forms at Annex A, so that the form in relation to fuel starts on page 9. And you will see that most of the information that's required, again, is the basic information that would be necessary for the mechanics of the deductions to be made, and indeed for the individual and their welfare benefits to be identified. There is simply the question on page 10, there's a box, please provide any other information on family or household background which may support this application. So it's not, it's a one-sided approach in two respects. It's one-sided because that question is posed only to the utility supplier and not to the benefit claimant. And it's one-sided because it asks for information that might support the application, as opposed to information which might suggest that the application is not in the individual's interests. And if then you turn over the page to page 11, you have section 4, customer participation. Does the customer know that this application is being made, yes or no? And then brackets, if not, please tell them straight away. It does appear to envisage that the applications may be being made to the Secretary of State where the customer hasn't even been told. And then we have an invitation to tell them, but no requirement. And then we see the same effectively in a slightly different format in the form for water direct on page 12.
It might be said that given the aims set out in paragraph 2 of this statement of intent, the passages you've been taking to us to go rather beyond the stated aims, because it doesn't have the stated aim of gathering information about the interests of the customer. It's got other aims, and that information might be obtained in other ways.
Yes, yes. I mean, this appears to be largely focused on what is in the interests of the utility providers.
Well, that may be going too far. I mean, 2A, the customer has a continuation or restoration of a fuel system. That's an aim which is in the interests of the customer.
Well, that's a fair point.
And so is 2B, no court action. So that there are customer-focused aims there, but they don't include the interests of the customer, which would explain why there's not a question about those interests.
May well do.
I mean, the overview does advise decision makers to consider contacting the customer as well as the supplier.
Yes.
I think your point would be, well, that's not good enough because
Absolutely.
they don't have a basis on which to make a decision about whether to do it.
Yes, and I'll come back to that when we look at the decision makers' guidance in the overview. But that is absolutely the submission that will be made. I won't go back to the details of the respondent's own case, but you will have seen from her statements, her own experiences have included deductions being made without her being told in advance that was the position. In terms of my learned friend Mr. Sheldon's reliance upon what he described as the pre-engagement, pre-decision engagement or involvement, neither the joint statement of intent, nor the spreadsheet, nor the licence conditions, and Mr. Sheldon took you to an example of those, involves any requirement for the claimant, the benefit claimant, to be told what the statutory test is, so that the claimant knows that there is actually an issue relating to their own interests, that they might have something to say. So they're not told that. And I do just ask the court to note, if your lordships have our supplemental skeleton argument in response to the skeleton argument of the interested party. Forgive me if I find the right reference. Yes, thank you. It's paragraph 5 of that supplemental skeleton, where we refer to a communication from the water provider to the respondent. And then if you go in the supplemental bundle, to the second supplemental bundle, to page 4, you have the text of that communication. And if you look at the about 5 paragraphs down, it refers to we're legally able to do this because the DWP stipulate that a proportion of a person's benefits are provided to pay for essential services. Water is deemed as an essential service, therefore if a customer is not paying us, we are entitled to take payments at source, i.e. directly from the benefits, and then reference is made to the joint statement of intent. So not only was the respondent there not being told what the statutory test was, she was actually being told wrongly that there was an entitlement on the part of the utility company to receive these monies.
Well, most people in this position, they know they owe the debt to utility companies. They're then told that utility companies apply to have it taken directly from their benefits. They're probably going to not have any idea that there's any right to other than that is done automatically. And I think many people in this position are just going to assume it's a fait accompli.
Absolutely, unless they're told that it can only be done if the Secretary of State is satisfied that it's in their interests and invited to say whether they have anything.
And they're never told that at any stage by anyone.
No, absolutely. So that's one of the first problems of the reliance upon what happens prior to the decision. A second problem, there's no obligation on the part of the utility company to provide to the benefit claimant the data, whether by spreadsheet or form or whatever else it might be, that they have provided to the Department of Work and Pensions. So the claimant won't know what information has been provided to the Department of Work and Pensions or whether it's factually accurate or not. There's no, the third point, there's no encouragement by the Secretary of State, still less any obligation imposed on the utilities provider, to tell the Secretary of State what the claimant's response to the proposal is. So the question is, have you told the claimant, not what does the claimant say in response to being told. The fourth problem, the practical one already identified by the court yesterday, is how does the claimant know where he or she should direct anything they want to say? And I think Mr. Sheldon referred to, well, you've got your local benefits office. As is apparent from Ms. Waterman's statement, third-party deduction decisions are taken by two specialist offices, the location of which temporarily escapes me, but they're set out in Ms. Waterman's statement, not by whoever might be dealing with the application for the underlying subsistence or other benefits. So those are a number of problems, and none of what has been shown to you by the Secretary of State actually goes to the heart of the statutory question. That's the most fundamental problem of all. Mr. Sheldon set out in his skeleton argument, paragraph 5, a number of matters which he suggested were common ground. They are not common ground for the reasons we've set out in some detail in response in our skeleton argument.
Yes.
I'm not proposing in the interest of time to go through those unless I get to the end of the rest of my submissions and still have ample time left. But I invite the court to note what we've set out there. If I can just pick up on one of the points that Mr. Sheldon makes in that part of his skeleton, which is the point about a claimant not being prevented from making representations at any stage of the TPD process. We've explained in our skeleton argument why that's unrealistic. And again, go back to the respondent's own experiences in that regard. And her own experience shows not being told that the application's being made in all cases, not receiving the application, not being told to whom she should make representations, and what she had said to the utilities company not being passed on to the Secretary of State. The detail of the benefit offices which deal with deductions, it's Handsworth and Barnsley are the locations of the two specialist offices, as set out in Ms. Waterman's statement at paragraph 21.
But as I think you've already indicated, perhaps the most significant is that people will not know there's anything to make representations about.
Absolutely. And if I can then just pick up, again, it's in broad response to a point in Mr. Sheldon's skeleton about the information available from the spreadsheet or form and then the person's electronic records. You have our general submission, we've looked at the spreadsheet, we've looked at the form. There's no indication as to what the Secretary of State's records would show that might be relevant to an assessment of interests. And as I would suggest became clear from Mr. Sheldon's response to questions from the court, there's no evidence that decision makers in the Handsworth and Barnsley offices actually pour through the benefits records in search of some relevant nugget of information. There is a reference in Ms. Waterman's statement to that they have them in principle available to them. That's the height of the evidence. There was a suggestion that the DWP decision makers would have health records. That's not quite what Ms. Waterman says. If we go to Ms. Waterman's statement, so it's tab 9 of the supplemental bundle, starting on page 149. and it's paragraph 160, sorry, page 167, paragraph 46. So we see there that the DM having access to system information within the DWP. They may also have access to customers' health records used in the work capability assessment. So it's a may. It's only going to be in certain instances, and of course that will provide. So it's not access to general health records, and it won't necessarily contain any information in relation to the position of the broader family. Can I then ask you to look at some exhibits to Miss Waterman's statement? So first of all, tab 11, starting on page 190. This is described as being a guide for water suppliers. And if the court looks at the section 7 content of the application, page 193, you'll see what's there set out. We must be able to identify the claimant from the details on the application for deductions. This should include the following where possible. And then there are a number of facts which go to identification. And then top of the next page, go to issues relating to the debt and other payment methods. It doesn't there contain anything that directly relates to interests or anything which relates to interests in any broad sense. There's then reference to we may need further information before making a decision, normally where the claimant has made the application. That, as I understand it, envisages that a claimant may make an application but not include all the information that's required in order to go through the process of making the deductions. And it's the same content in the Guide for Fuel Suppliers. It starts on page 197. Section 7 of that is on page 200 and is effectively an identical format. So nothing there to direct the providers to gather together the information, or at least some of the information, that might assist in answering the statutory question. And then if we could turn to tab 14 of the bundle, page 207, you have there the first of two versions of a note produced by Miss Waterman. She explains the differences, or the reason for the differences between the two in her statement, and I won't go to that. But if we turn to page 208, the last three paragraphs, having referred in the previous sentence to the statutory requirement, so determined that a legacy TPD is in the interest of the family, she says in terms, at present, we do not gather enough information from the supplier or the claimant to enable us to make a judgment at this point. We assume the supplier has completed their actions and we do not gather enough information to consider the interests of the family. And then there's a suggested process improvement required. Update the spreadsheet or forms by asking for a summary of the action they've taken, and that may no doubt explain why we have one of the additional boxes in the spreadsheet. Claimants need an opportunity to disagree or challenge this process at some point. At the moment, this is only at the point of MR, that's mandatory reconsideration/appeal. We need to consider giving claimants time to provide us with information should they wish to. Over the page, process improvement required, notify claimants of the request for TPD, allowing them time to reply if they wish to. So that was what was set out in the first version of Miss Waterman's note. The second version starts on page 211. I'm not going to do a line-by-line comparison. My lords can read it for yourselves. But if we look at page 212, the last paragraph, she says, at present, I do not believe that we gather enough information from the supplier in the Excel spreadsheet. It is possible that we do not seek sufficient information from the supplier or possibly the claimant to enable us to make a judgment at this point. From my discussions so far with operational colleagues, they appear to assume from the spreadsheet that the supplier has completed their actions without necessarily checking further with the supplier or claimant, or looking further than the spreadsheet, although I'm looking at this, if the Excel spreadsheet is relied on by itself, I doubt we are gathering enough information to consider the interests of the family. And then over the page, bottom half of page 213, beginning, claimants need an opportunity to disagree or challenge this process at some point. At the moment, there is that option at the point of MR appeal. However, so far I'm struggling to find records of this being done earlier, though the DMG provides for this, and I'm continuing to look at this to prepare my statement. I can see, so this is the second version of the one which he says more accurately reflects her views. I can see a strong operational case for giving claimants time to provide us with information, should they wish to, before all decisions are made. And then process improvement required. Notify claimants of the request for TPD, allowing them time to reply if they wish to. Reading that, it is difficult to understand in my respectful submission why we are here at all. Now, it is right, of course, that the amendments to the spreadsheet were made after this, so part of Ms Waterman's thinking feeds into the additional boxes in the spreadsheet. But for the reasons I've already set out and which are set out in our skeleton argument, those additional boxes don't correct the identified defect. They don't go far enough.
Well, is she identifying the defect as a failure to gather enough information to determine the interest of the family, or something else? It's a bit, I'm not quite clear about that.
That's what I understand her to be
Because
saying.
she's talking on this page that we've just been looking at, 213. There's talk about updating the spreadsheet to ask for a summary of the action taken and so forth, and giving the claimants an opportunity to challenge that process. And then we move on to the strong operational case, which note is not a strong legal case, but a strong operational case. I'm finding it a little difficult to see this as a clear statement that there's any strong case for giving claimants time to provide us with other information apart from that which the updated spreadsheet is going to.
That's certainly not how I'd read it, my lord. I'd read it as being information going to the interests of the family requirement. The spreadsheet never goes to the claimant, so they can't comment on the spreadsheet. You rely on
the bit under process issues on page 212.
Yes. Yes, there's nothing in the post Waterman note changes that have been made that say, right, here is what we've received from the utility supplier. Comment on it, because there is still no contact whatsoever made as a matter of course with claimants. So the reliance is still 100% on the information that's provided by the utility provider.
But I understand from Mr. Sheldon's submissions that part of the case being mounted is it wasn't effectively practical or sensible to make these inquiries due to timescales, etc. What do you say about that in the context of this note referring to operational case?
Well, I say in the context of this note, there's no foundation whatsoever for Mr. Sheldon's submission. Ms. Waterman clearly identifies no such problem. Stepping back from this note, it's frankly fanciful to suggest that building into the process the sending of a letter to a benefit claimant which articulates that an application's been made, articulates the amounts, all of which is data that is easily available to the DWP, sets out the statutory test and says, please let us know in 14 days if you consent, or if you don't, if you have anything to say, how that creates any practical difficulty whatsoever. In the context of the Department of Work and Pensions, which is, Mr. Sheldon said, there's lots of contact between individuals and benefits office. Individual benefit claimants may have different experiences of how useful that contact is, but the suggestion that that letter cannot be sent is fanciful in my submission, and certainly no foundation for it in the evidence that was before the court. The evidence that was put before this court for the purposes, put first before the court below and then before this court in relation to the stay, there has been no application to rely upon that for the purposes of the substantive appeal. Mr. Sheldon has made no reference to it. But even if one does look at the statements of Carroll and Crown, which are at tabs 25 and 28 of the supplemental bundle, one can see why they're relied on in relation to a stay, because they say, well, it's going to cost us money. We have a contract with people to write template letters for us. There's a cost to opening the letters in reply that we get from the claimant. It's a slightly puzzling feature of her statement. And there is, we will have to give additional training because if people are going to have to consider representations from claimants, that's what she says. None of that goes to it being problematic or inconsistent with the overarching purposes of the legislation or anything of that kind. And any period of time which elapses in terms of the sending out of that letter and the 14 days or so that I plucked 14 days out of the air, but whatever period of time it might be for a response from the claimant, and my learned friend suggested, well, that causes some further delay. But that needs to be looked at in the context of the whole period of time. We still don't know what the time period is between the receipt of the applications and the decisions being made. Mr. Coppell said his client's experience was that it was pretty quick, maybe because there's rubber stamping going on rather than the proper exercise of statutory decision making. But leaving that aside, actually, if you're looking about the impact of an additional 14 days or thereabouts, you need to look at that within the context of the whole time frame, which will include all the dealings between the claimant and the relevant utilities company. There will have been, we are told, lots of engagement to explore different payment mechanisms and so on. So difficult to understand why a short further period of time is so problematic.
I see from Ms. Waterman's statements that it seems that she thinks that what was done with the spreadsheet addressed the concern she expressed in her notes. Is that how you read it?
Yeah, is there a particular paragraph my Lord has in mind? She certainly wasn't accepting that there was a deficiency as at the date of the reference.
It starts at paragraph 49. And then 50, she refers to her instigation.
Yeah, so that's her explanation of the differences between the two notes.
Yeah. And 51 is the number of meetings and some concerns expressed. And then I believe we managed to overcome those difficulties in a reformulated spreadsheet. And then she refers to the fact that the further information box is described as not mandatory. This means the spreadsheet will not fail to upload if there's no information input in the column. That's the any other information.
Yes. Yes. So it may be a reasonable inference that she's saying, well, that's sufficiently addressed my concerns. For the reasons I've already given in my submissions, the spreadsheet doesn't sufficiently address the legal issues.
I think that's what it doesn't address her concerns, does it? Because it does not address the concern that we do not get enough information about the interests of the family.
Absolutely. Simply asking, is there any further relevant information, clearly doesn't address that. Whatever her own view of the position might be. And of course, we'll come on to this when we look at the fairness case law after the short adjournment, but the question of what is fair and what is required as a matter of fairness is a question for the court. It's not a question for the discretion of the public body. But I can pick up the authorities at 2.
Thank you very much. We'll resume at 2 o'clock.